Raphael Glover, and this is cause number 24 DCCR 0232. Mr. Glover's case was set for trial a couple of weeks ago. We were about to start with jury selection. Mr. Himmler filed a motion to quash the indictment based on some relatively new cases that have come down from the Fifth Circuit as well now from the Supreme Court with regard to underlying offenses on unlawful possession of a firearm by a felon. I have done a substantial amount of reading of those cases and reviewing all of that since the last court date. I know your position, obviously, Mr. Kimmler, Mr. Nichols. What is the state's position?
Judge, after looking at those myself, I think we're in the Fifth Circuit case dealt with the underlying felony of being a simple possession of drugs. The Supreme Court ruling wasn't so much felon possession of firearm, but a firearm in the possession of a firearm by a drug user. So that was kind of the main theme under all those cases was simple possession, simple drug use does not equal dangerousness. In this instance, Mr. Glover's prior is for child endangerment. And while it is some years ago, on its face, that is reasonable to deduce that's a dangerous prior felony. He also has the intervening felon possession of a firearm in the years since that original conviction. So I think in this instance, the state can make a very clear argument that he's shown a history of dangerousness and that the prohibition on possessing a firearm by a felon should apply and the motion to quash should be denied.
All right, thank you. Anything else to follow up?
Other than just, I think the inquiry is dangerousness, and obviously drug cases are a subset of dangerousness, lack of dangerousness, but I don't think the ruling is limited simply to drug cases. I think the court's research probably reflects that. The question is whether the underlying felony conviction of endangering a child rises to that level of dangerousness so as to preclude his ownership of firearms or possession of firearms. I would just note that at the time he pled to that, there was no DWI child passenger statute. And I think had that statute been available, that's probably what he would have pled to. And then you obviously wouldn't have the endangering language and the conviction itself. So that is something that I would ask the court just to note that should the case just not to take notice of the fact that if the case were indicted today, it probably would not have been pled as an endangering child, DWI child passenger, and whether DWI child passenger cases are inherently dangerous, I guess, is another inquiry as well.
So there's nothing at this time in these newer line of cases that is specific with regard to any other real underlying type of offense other than possession of a controlled substance or possession of a drug of some sort. And I'm not going to start going down the road, I think, of making those decisions unless it is real clear. I think for whatever reason that underlying offense should not be included. And so I am going to deny the motion to quash, and we will get this case set back on the trial docket as quickly as we possibly can.
I think it's currently, it has a trial.
Is it still already? Okay, it is. All right. And just also part of that finding that I'm making is based on the actual facts of the underlying case, regardless of whether or not it's an endangering a child or nowadays a driving while intoxicated with a child passenger. I would think regardless, it's the same, that the facts of this case as reviewed with a young, I think it was a 9-month-old or 8-month-old sitting in the lap of the passenger in the front seat of the car. I think that in and of itself is dangerous, whether it's a DWI or an endangering a child, either way. So that is the basis of my finding. So we will move forward with trial at that next court date.
Sure.
All right.
Thank you.
You can, you're free to go, sir. I don't have an order. If someone would prepare an order, please.
Yes.
Ms. Hingston?
Yes.
And Mr. Hingston, did you get someone hired?
I asked them question on and I've counted just a little too high right now.
Are you working?
Yes, ma'am.
Where do you work?
JP Fulfillment Warehouse.
Okay. If you want, I can have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer, or I can give you one more reset to see if you can hire someone. I don't, with your income, I'll just have to take a look at it to see if you qualify, but if you want to fill out that paperwork, I'll let you.
I'll at a instance, so I might be trying to hire.
All right, well, you've been coming a few times now, so you need to try to get him hired before that next court date. If you get Mr. Adams hired, bring the reset notice to him. If for some reason you're not going to be able to, talk to some other attorneys, also bring a pay stub and we'll get you to fill out that paperwork next time. All right, step in front of the clerk. Terrence Jenkins, one of your Terrence Jenkins?
Yes.
And Mr. Jenkins, did you get someone hired?
Several people. So Williams Law Firm said they're charging 10,000. Walker Law Firm to me is charging 15,000. Franklin said they're charging 10,000. I got them say 500 Frank, and so get a part decided in 2,500 after.
So,
I'm not working right now. The job I was supposed to get in the background didn't go through, so I couldn't get hired. And I'm waiting on the HR to call me from my old job to see if I'm eligible to be hired for the charges.
I'm gonna have you, thank you for doing what I asked you to do, Mr. Jenkins. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. You step in front of the clerk on the end, she'll give you that paperwork. Good morning. Are you David LeBlanc?
Yes,
And Mr. LeBlanc, this is your initial appearance. Can you hear me?
yes,
This is your initial appearance in cause number 26 DCCR 0644. You're charged with a third-degree felony offense of theft of property, and that's from July 21st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I've just talked to my lawyer Friday,
Okay, who's that?
Ralph Kimler.
Okay, and you're going to hire him on this case?
Yes, ma'am.
So what I'm going to do is reset your case about 30 days to give you some time to get Mr. Kimler hired. If you do get him hired, make sure you bring the reset notice that you get today to his office and they'll tell you what to do. If that's not going to work out for some reason, then you need to talk to at least 3 other attorneys before that next court date and bring me those names so that I know you're trying. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you a reset notice. Good morning. Are you Akaya Nash?
Yes, ma'am.
And this is 26 DCCR 0206. Ms. Nash is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I spoke with Ms. Nash and who's to stay in this situation. We've gotten an offer on it. There's an alternative offer there as well. So I just need a little time to talk to Ms. Nash to see what's going to be which option she wants to proceed with.
All right, we'll just do one more reset. Ms. Nash, it's important that you make an appointment, go visit with Mr. Lewis before that next court date so y'all can go over all.
This courtroom moment highlights how legal arguments don't always succeed, even when backed by recent high-level rulings. While the defense relied on new Supreme Court and federal decisions suggesting that not all felonies justify firearm restrictions, the judge focused on one critical factor: dangerousness. What made the difference here was the nature of the defendant's past conviction. The court emphasized that child endangerment, especially involving an infant in a risky situation, demonstrates a clear level of danger to others. This ruling shows that courts don't just look at the law in isolation, they examine the real-world facts behind each case. Ultimately, the judge decided that public safety outweighs the defense argument, sending the case forward to trial. It's a powerful reminder that context matters in every legal decision.